Moving on to the next section of our rules. This is litigation and other forms of advocacy. This makes up 10 to 16% of your total MPRE examination. The first rule that I would like to cover here is candor to the tribunal. So here the rule states that a lawyer shall not knowingly do the following. First, they shall not make a false statement of fact or of law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So this simply means don't lie. Do not misrepresent facts. Do not misrepresent the law. This also means that if you have previously represented, say, certain facts regarding your client's case to the judge, and you come to find out that it was a lie, or maybe your client misrepresented them to you, you have to correct that information with the judge. Either way, you cannot stand next to a lie. So you can't knowingly lie, or if you come to find out that you made representations that are false, you have to correct those. The second part of this rule says a lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Turning to our example here, it says a lawyer is arguing a motion in State A. There are two cases on point with very similar facts, however, not favorable to the lawyer. One is from a lower court in State A, and the other is from the highest court in State A. There's also a case on point in State B. Lawyer has to disclose both cases from State A because they come from the controlling jurisdiction. Lawyer does not have to disclose the case from State B because it is not in the controlling jurisdiction. The other thing I like to point out about this portion of the rule is that this rule uses the word knows. So if you know that there is controlling law that opposing counsel has failed to bring up, and that law happens to hurt you, you have to bring it up because you know about it. But if you do not know that there's, say, some case out there that hurts your client's position and opposing counsel has failed to raise it, well, then you're not obligated to bring it up either. Why? Because it only requires that you make this information known to the judge if you know about it. So if you do not know about it, then how could you possibly bring it up? That might sound silly to you, but again, that's a question that I have been asked a million times. So remember that this portion of the rule utilizes the word knows. The next part of this rule says that a lawyer shall not knowingly offer evidence that the lawyer knows to be false. If a lawyer or the lawyer's client or a witness that's been called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial action, including, if necessary, disclosure to the tribunal. The whole idea here is you can't put someone on the stand and let them lie and know that they're lying and not do anything about it. Or if you put someone on the stand and they testify and you come to find out that they testified falsely, you have obligations as well. You cannot stand next to that lie. So what are those steps that you must take? First and foremost, if the lawyer finds out that testimony is false or knows it is false, then the lawyer should first talk to their client in confidence, advising the client of the lawyer's duty of candor to the tribunal and seek the client's cooperation with respect to either withdrawing from the matter or correcting the false statements or evidence that has been presented. It's always good to first level with your client, make them understand your obligations to the court so they understand that you have to take action. If this fails, then the lawyer must take further remedial action. The rules state, or I should say really the comments illustrate, that if withdrawal from this representation is not permitted, or if withdrawing from representation will not undo the effect of the false evidence, then the lawyer must make a disclosure about the false evidence or testimony to the tribunal, as is reasonably necessary to remedy the situation at hand, even if doing so requires that the lawyer reveal information that would otherwise be protected by our duty of confidentiality. From there, the tribunal will take it. They will figure out what the appropriate steps are to take after you give this information up. It's also helpful to understand how long this obligation exists. So here the rule says that this duty continues until the end of the proceedings. So this means that a final judgment has been affirmed on appeal or the time for appeal has passed. So just to make sure we're all on the same page here, this means that if I put up a witness on the stand, they testify under oath, and I do not know that they're lying, and I do not find out that they lied until 2 years later, and the time for appeal is far over, I have no obligation to correct it because the proceedings have ended, and I found out about this falsity after my duty ended. To give you a different example, if I put someone on the stand and they lie, and I come to find out the next day that they in fact lied, I would have an obligation to take action because the proceedings are not yet over, so therefore my duty was continuing. It's also good just to reiterate the fact that this rule uses the word knows again. So this prohibition against offering false evidence only applies if the lawyer knows rather than suspects that the evidence at hand is false. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that evidence is false, however, can be inferred from the circumstances. So the big takeaway is, if I think someone's lying to me, but I really don't know, and I put them on the stand, and I think they might be lying, but I really don't know, I do not have an obligation to correct anything because I don't know whether or not they're lying. But if someone tells me the truth and then they tell me that they're going to lie and they want to be put on the stand, then I cannot do that. I can't stand next to false evidence. Or if they tell me the truth and then they testify to the opposite on the stand, that I would have the obligation to take action and to correct that evidence. The next part of this rule that I want to discuss illustrates what the lawyer has to do if they know that someone is going to testify falsely. So we just talked about what happens if you know that someone already has testified falsely. We have these obligations such as possibly withdrawing and or correcting it and letting the judge know about that false information or testimony. Here we're talking about what you should do if you know someone wants to testify falsely. And your obligations differ if you are representing a civil client versus a criminal client. So starting with our obligations in a civil case. Here the rule says if a lawyer knows that the client intends to testify falsely or wants the lawyer to introduce false evidence, the lawyer should seek to persuade the client that the evidence should not be offered. If this persuasion is found to be ineffective and the lawyer continues to move forward with the representation of this client, the lawyer must refuse to offer this false evidence. If only a portion of the witness's testimony is going to be false, then the lawyer may call the witness to testify, but may not elicit or otherwise permit the witness to present the testimony that they know to be false. So in other words, try to explain to your client that you cannot offer false evidence or testimony, maybe threaten to withdraw if that's going to correct it, which most of the time it doesn't. But if push comes to shove and your client insists on false evidence or falsely testifying, just simply don't put them on the stand in a civil case. In a criminal case, however, your obligations are different. So here the rule says, because of the protections that are involved in criminal matters, and the Sixth Amendment protects a criminal defendant's right to testify, a lawyer who knows that a criminal defendant is going to testify falsely should do the following. First, try to persuade that client to not testify falsely. Again, try to level with them. See if they can try to understand your obligations and agree to not testify falsely. Then you should consider withdrawing, specifically if this solves the problem. However, it usually doesn't. If that doesn't work, then you should reveal the situation to the judge, and the judge gets to decide how to move forward and what to do. So again, the big difference here, in a civil case, you do not have to put your client on the stand. In a criminal case, you do. That's why your steps that you have to take here under the circumstances differ a little bit. The next rule that I want to talk about is all about trial publicity. So here the rule says a lawyer who is participating or has participated in the investigation or in the litigation of a matter, or any lawyer that is associated in their firm or government agency shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in a matter. So first things first, this rule is basically saying if you are participating in litigation or in the investigation of something, you shouldn't make statements that are going to be disseminated to the public that are going to prejudice the matter. This rule also says that anyone in your firm should also not make these statements, or anyone involved in a government agency that is involved in a matter shall not be making these types of statements either. So it's a rule that kind of encompasses everyone involved. I really like this rule because then it goes on to basically illustrate all of those things that attorneys can state regarding the investigation or a legal proceeding. And then it goes on to basically tell you all of those things you shouldn't state. So this is an excellent rule to memorize. The more familiar you are with this rule, the easier these questions are going to be. So taking it from the top, those things that a lawyer may state are as follows. The lawyer can talk about the claim, the offense, or the defense involved, and except when prohibited by law, can talk about the identity of the people involved. Lawyers can discuss information that's obtained in a public record. They can discuss the fact that an investigation of a matter is in progress. Lawyers can discuss the scheduling or result of any step in litigation in the matter. Lawyers can request assistance in obtaining evidence and any information that's necessary to the matter. And lawyers can give out a warning of danger concerning the behavior of persons involved, and when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And in criminal cases, in addition to all of those other things we just discussed, lawyers can also discuss the following things. Lawyers can talk about the identity, residence, occupation, and family status of the accused. Lawyers can discuss if the accused has not been apprehended, information necessary to aid in the apprehension of this person. They can discuss the fact, the time, and the place of arrest, and also the identity of investigating and or arresting officers or agency, as well as the length of the investigation at hand. Turning now to those things that a lawyer may generally not make statements regarding. First things first, is that they should not talk about the character, credibility, reputation, or criminal record of a party or of a suspect in a criminal investigation or of a witness, or the identity of a witness or the expected testimony of a party or of a witness. Lawyers should not talk about in a criminal case or in a proceeding that could result in incarceration the possibility of a plea of guilty to the offense or the existence or contents of any confession, admission, or statement that's been given by a defendant or by a suspect, or that a person has refused or failed to make a statement of some sort. Lawyers should not talk about the performance or results of any examination or test, or the refusal or failure of a person to submit to some sort of examination or test, or the identity or nature of any physical evidence that's expected to be presented. Lawyers shall not talk about any opinion regarding the guilt or the innocence of a defendant or of a suspect in a criminal case, or proceeding that could result in some form of incarceration. Lawyers should not talk about information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and if were to be disclosed, creating some sort of substantial risk of prejudicing the trial. Lastly, lawyers should not talk about the fact that a defendant has been charged with a crime. Unless included in that statement, it also explains that a charge is merely an accusation and that the defendant is going to be presumed innocent until found guilty. And then lastly, we have an exception to this rule to wrap it up. We call this the right of reply. So here the rule says a lawyer may make a statement that a reasonable lawyer would believe is required to protect their client from substantial undue prejudicial effect of recent publicity that has not been initiated by the lawyer or by the lawyer's client. This is so even if the statement might otherwise raise a question under this rule. The statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So let's say you are representing a criminal defendant, and let's say the prosecutor has been speaking to the media and has been making very questionable statements about, say, your client's refusal to take a lie detector test, or your client's refusal to make a statement, or something like that. Something that the prosecutor should not be saying to the press. You, as the attorney for the defendant, have this right to talk to, say, the media and try to clear the air. This is so long as you or your client were not the ones that have made basically contact with the media in the first place. So assuming that the prosecutor was the one who kind of reached out to the media and made these statements that were obviously very prejudicial and questionable under the rule, then you, as the attorney for the defendant, could make statements to kind of set the record straight. You could even make statements that might otherwise be questionable under this rule, to again try to balance the scales and clear your client's name and try to undo whatever little bit of prejudice may have been raised or made. And then the last rule I want to talk about in this subsection is lawyer acting as a witness. So here the rule says lawyers should generally not act as a witness absent an exception. It says a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness, unless the testimony relates to an uncontested issue, the testimony relates to the nature and the value of the legal services rendered in the case, or the disqualification of the lawyer would pose a substantial hardship upon the client. So here, just stopping, if you know you are a necessary witness in a matter and someone comes to you and asks for you to be their advocate in that matter, you should say no, unless you are going to be testifying to something that's uncontested, or your legal services, or if you are already their attorney and not testifying or withdrawing would cause that substantial hardship upon your client. It's also good to know that you can act as an advocate in a trial in which another lawyer in your law firm is likely to be called as a witness, unless precluded from doing so by the conflict of interest rules. So that wraps up this subsection of the rules here, and we are moving on to the next part.